Welcome to another episode of Girl, Is That Legal? With your host, Attorney Simone Redwine. Welcome. Thank you guys for joining us again. I've missed you guys. I really missed you guys over the weekend. So much legal foolishness has occurred in just this first business day that I could not wait to get back on. I actually was out of town, so I hurried back so that we can chit chat. Definitely drop where you're watching from in the comments. I'm Attorney Simone Redwine. I'm actually a lawyer, not a law student, not any of that. And I'm actually a law professor. So I actually teach the law. So I'm really excited about the new followers and the new people that have been viewing. Yes, hit that like button. Good to see you, RPC. Hit that like button. I wanted to start by thanking everyone and saying thank you so much for watching, and thank you to all of those who have subscribed. We hit 21,000 viewers this weekend. I'm super excited. All right, Miss Joy, I see you're watching from Virginia. And what I want to do today I was going to cover both Trump's, the ruling the Supreme Court had today on Trump, as well as the YSL trial. And while people are coming in, I will start with Trump. But I wanted to actually play the footage today from Judge Glanville's so-called ruling, his decision. And I want to break it down for you guys. Now, that ruling is only about 30 minutes, maybe a little bit less, about 27 minutes. And I'm going to speed it up and we're going to go through it because, baby, it's some bull honky. It's some bull going on there. And I want to make sure that you know what's really going on. So here we go. Hold on. Let me pause this. Make sure I got my do not disturb on because I'm getting text message. Here we go. Hey, okay, so we got Regina from Vegas. Hey, Regina, I should be in Vegas later this month. The National Bar Association, which is the Black Attorney Legal Association that represents, not represents, but that most Black attorneys in America are members of. They're having their conference in Vegas this year, and it's always so much fun. Cece, hey, Cece from Florida. We got Candace from Houston. Cece. So y'all, while everyone's joining, I'm going to start by talking about Trump and give you the overall gist of what today's Supreme Court ruling means. Now, it still sucks. It's still stupid. And it went down party lines, meaning the Republicans let him do whatever the heck he wanted to do, the Republican appointed justices, and the Democratic appointed justices, which it was only 3 of them, so it was 6-3. Those justices said, hell no, you can't just do whatever you want because you're president, basically. So Kimberly George, good to see you. So let me tell you in the most layman's terms what the Trump's Supreme Court ruling means today. Now, the way my ADD is set up, I tend to learn best through forms of analogies. So basically what they're saying is he doesn't have complete immunity, which is what he wanted, to do whatever he wanted. But what they're saying is that the acts that he has done in his presidential capacity as president, so anything that was presidential, so to speak, that he has immunity for those acts, and that it's my understanding that the only way he could be removed for those acts would be if he were impeached by both the House and the Senate, right? We went through the impeachment process. The House impeached him. The Senate could not agree because at the time the Senate was majority Republican. Okay. That's kind of always been the rule, but it's saying that things he does on a personal level. So for example, like the Stormy Daniels stuff, that stuff he did on a personal level. He did not do that as a president. First of all, the Stormy Daniels and paying her off, that happened before he took office. But if he did it while he was president, and still paid off a stripper just so she wouldn't, not a stripper, but a porn star, just so she wouldn't tell the story, he could be in trouble for that, right? Because paying off strippers is nowhere near part of your official presidential duty. This is the best analogy that I could give, all right? So love to see questions in the chat. Again, thank you guys for continuing to join. Hit that like, hit that subscribe. By hitting that like, it's totally free, but that tells YouTube to continue to recommend it to other people so they can join us. But the best analogy of basically what the Supreme Court is trying to say here with this Trump immunity ruling is this. Again, they're saying anything you do in your official capacity as the president, you're immune for, meaning, and the point of that law is to prevent regular people from suing the president because we don't like what he's done. That's the overall point. So an analogy on the state court level is, remember how Ron DeSantis took like that bus full of Latino migrants, right? And shipped them to, I think he dropped off a group in front of Vice President Kamala's house and another group like in New York City or some random place. How he did those things, right? Hypothetically, DeSantis is immune from prosecution for kidnapping for that act, right? Otherwise, if I did it, if I took a group of migrants who were being told, hey, we're taking you somewhere nice, and I dropped them off in Washington, D.C. in front of Kamala Harris's house without their consent. There was no consent for that, by the way. If I did it, it's kidnapping. By him doing it as the governor, he's immune because he made that decision in his role as governor, okay? Similarly, if the president were to do something like that, literally kidnap a bunch of people as president and drop them off in a Democratic city, hypothetically, they're saying he couldn't be criminally prosecuted for kidnapping that group of people. I hope that kind of helps. Feel free to drop questions in the chat on that one. All right, now that I've touched on Trump, and we can go into that some more tomorrow when we have a little more time. But y'all, this Judge Glanville situation, I was like, this is some foolishness. We're going to go into that one. Somebody said, yes, no replay gang from me today. Oh, I understand. Yes, no, today is definitely live. Like I said, I missed you guys. But when we're going into this, somebody, he said presidents don't go to jail. Unfortunately, they should. Now, again, if he were to commit a crime, if he were to pow somebody, right, because he was mad at them for sleeping with his wife, as an example, then if he were to do that, absolutely, he could be prosecuted for that, is what they're saying. But because that was some decision he made not as a president, it's in no way a presidential decision. That's the decision that someone has made for their personal life. So that's kind of the contrast there. All right, now let's transition into this YSL RICO and why Judge Glanville. I believe, based on what happened today, is done. Done, did it. We know Diddy is done. And I believe that basically, with respect to Glanville overseeing the rest of this case in a way that comports with the law, no, ain't no way. We're going to go over that. I want to tee up where we're at today. So what was supposed to happen today? Today, well, actually, when everything started today, the court started by the judge going on the record and setting up a timeline of the events, is what he recounted. Effectively, what the judge was trying to do today is cover his black behind. He's over here covering his behind. I'm going to tell you what he ultimately ruled, and then we're going to tell you why he got there and why this mattered. What he ultimately said is he's going to recuse himself. Now, when everything first popped off, which was that the issue was that he had what appears to be an illegal or improper, not illegal, but an improper ex parte, mean one-on-one private conversation between YSL Woody. It's actually Woody, not Woody. YSL Woody, YSL Woody's attorney, Caleb Bumpus, the state prosecutor, and himself. When he had that initial hearing and didn't tell defense attorneys about it, the whole issue is you cannot take somebody in the middle of testifying after you done locked them up for the whole weekend for choosing to plead the fifth. You can't have a private meeting with them without inviting the defense. It's law school one-on-one. It's law school one-on-one. You cannot do that. And he did. So that's what started this. Then what happened was on the record, Brian Still, which is Young Thug's lawyer, asked the judge to recuse himself. Recuse meaning step down, fall back, fall off the case. Of course, he said no. That would be an admission that he had done something wrong. So then Brian says, all right, well, if you're going to hold me in contempt, which he was doing, if you're going to lock me up, I'm appealing this and I'm seeking a hearing to have evaluated whether this is fair. And I'm asking you to, at a minimum, recuse yourself from the hearing over whether or not what you did was fair. Like, again, if you've been to 3 years of law school, you should know that at a minimum, yes, you cannot be the judge over whether or not your decision to not recuse yourself is fair. Like, you're going to do that. I think what happened is over the course of the weekend, Judge Glanville probably met with attorneys, he met with advisors, and he realized he was dead wrong. So today, although previously he said, nope, I'm not recusing myself, I'm not stepping down. What he said is, I'm not stepping down from the whole case. No, I'm not doing that. But I will step down from the case that's going to oversee whether or not I properly held Brian Steele in contempt. That's what he's saying. I'm not going to oversee that. I'm going to let a different judge do that. And what is it, on the 3rd, which was supposed to be Wednesday, was supposed to be a hearing where he was basically going to probably lock up Kayla Bumpus and YSL Woody, the show cause, and have them basically tell whether or not they were the ones to tell Brian Steele about the meeting. So he wanted to have what's called a show cause hearing. The show cause hearing was to basically ask attorney Kayla Bumpus for YSL Woody and ask YSL Woody, hey, were y'all the ones that told Brian Steele about our illegal meeting? This gets stupider and stupider. It's so dumb. But what he said today, which comports, he said he has postponed indefinitely that hearing because hypothetically, if attorney Bumpus or YSL Woody didn't want to say like whether or not they said it or whatever, he likely was going to try and lock them up too, which again, if he's read anything over the weekend, if he's consulted with attorneys, if he's consulted with people that know the law, then he would know you can't do that. You can't do that. So that's what he tried to set up. We're going to go through his statements and why his own statements that he gave in this hearing today likely are part of what has him cooked. Before we do so, we got a good question on the floor. Kim was here when I gave the little summary about what the Supreme Court's decision today means for Trump. She's asking, so does that mean Trump is exonerated from the New York trial indictments? No, not all of them. So I'm going to do a more extensive one. So basically, no. And for New York trial, there's a number of different things. So I believe New York was the Stormy Daniels and no. Yes, New York was Stormy Daniels. He's got a few. For Stormy Daniels, absolutely not, because the Stormy Daniels stuff, remember, that happened before he took office. So what happened, and it was something he did for his personal self. That was not something he did as an action as a president. In fact, he worked out the contracts. He did all of that. He just made sure that the money didn't transfer until after the election. But all the negotiations, all the stuff that got him in trouble happened before the election. So there's two reasons why the New York indictment will stand. Is one, because of the fact it happened primarily before he even all of it happened before he won the election. And then I believe the payment was either after the election results or it was after the inauguration, one of the two. But then secondly, the reason that will stand is he didn't make that call as a presidential decision. That's why I compared it to Ron DeSantis' decision to take the bus full of immigrants and drop them off in front of Kamala's house. That example, if anybody else did it, would be kidnapping, right? But because as the governor of that state, he chose to do that as a mode of dealing with immigration, which he can do within the bounds of his rights as governor, DeSantis. That would be an example of being within the realm of your immunity as a governor. Similarly, if Trump were to do something like that, it would be within the realms of president and he couldn't be tried, for example, for kidnapping. So that's how I got that. Somebody said he won't serve a day. Seriously doubt it. I think for New York, he probably won't serve either because I think the judge is going to give him probation or house arrest, something like that. I also think he's going to continue to postpone and appeal things to just push it until after he becomes president. And then at that point, he'll use some other exception to be like, oh, I'm so busy being president. I ain't got time for none of this. All right. Going back to the YSL case. Ooh, yeah, going back to the YSL case. This is true, states President Biden has immunity as well. So be careful what you ask for. Ain't that right? Hit that like button if you could, please. You got 87 people is what I show in the chat. And minimal likes. You want to hit that like button. Actually, hold on one second. Yes. Hit that like button so we can get that up. Again, that's how they decide to recommend this over to, oops, there we go. Recommend this to others on YouTube. So we want to get that going. Here we go. Yeah. There we go. Ooh, ooh, ooh. All right, I'm teeing up. We're going to see this video. Where is that? All right, there we go. All right, here we go. So come on back. Let's do this share screen. Here you go. I'm going to share it and share the audio. Ooh, ooh. All right. So we ain't gonna have to be bored.
Made aware of last week, the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion.
All right. So what was supposed to happen today? What was supposed to happen today was that it was supposed to be an opportunity for both sides to review the transcript for the discussion, that the ex parte hearing. So the discussion that went on in the judge's chambers between the judge, the state, YSL Wody, and his attorney. Because remember, what was alleged was that in that discussion, so the Friday before, YSL Wody was supposed to testify. He pled the fifth. The judge then locked him up for contempt because he had already had immunity. If you have immunity, you cannot plead the fifth, because pleading the fifth says, I'm protecting myself from the risk of being tried for something criminal related to what I'm about to testify. Because when you're given immunity, it takes away the ability for anyone to try you for your testimony. You have no reason to plead the fifth. Basically, you have no reason to say, I'm scared. I don't want to testify because I could go to jail for it, because they're telling you, no, you can't go to jail for it. We're promising you. So that happened the Friday. Over the weekend, YSL Wody goes to jail. That Monday morning, there is the discussion in the judge's chambers, and therefore that discussion was transcribed. So all the defendants, not just Young Thug, but all the defendants' lawyers want to see a copy of this transcript. At first, the judge they were talking about like possibly redacting sections and da-da-da-da. What he's saying is that, hey, he was going to give everybody a copy today, and now let's see what he decides.
For review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts want. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as Courts 2. So the transcript will be Court 1. His immunity agreement, Mr. Copeland, will be Court 2.
And I'm going to be breaking this down and pausing to explain.
And advise of his rights and obligations during the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings. Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024.
All right, so Mr. Melnick is YSL Woody's original lawyer. Mr. Melnick was about sick of this ish, because he felt that, like, look, I've negotiated so that my client could get immunity. my client is able to basically testify. He has immunity. He planned a vacation or has something else to do. And so on Friday, when his client, after he done did all that, decides he wants to plead the fifth, the court it just throws everything awry. And he's also, Milnick, YSL Woody, that Friday is trying to withdraw as the counsel. The judge, or because he's basically saying, I got other things to do, Your Honor. I've been doing this for 5 months. Here's what's important to understand about the Milnick situation with the original attorney and then the stand-in attorney. See, a lot of people don't realize, especially if you've never been a criminal, when you come to us and you ask us to represent you for criminal law matter, we charge you a flat rate. It's a flat rate. Now, some criminal attorneys charge you one flat rate, whether you go to trial or not. Then others will say, this is the flat rate for me to represent you up until we get some plea agreement and agree to it. And then I'm going to charge you an additional amount if you don't take the plea, whatever we got agreed, and you require a trial. You want to go to trial. And for a case like this, easily $50,000. And it could easily be $50,000 just to get you the plea, but another $50,000 if it's going to be a trial or more. And that is because a lot of and more than likely, if that attorney started representing him before they picked the jury, that attorney had no idea this was going to go on as long as it was. So therefore, more than likely, this attorney quoted him a price thinking, all right, this might be a month or something. And it may have extended now to this 5-month process where this attorney has other cases, he has other matters that he has to tend to, because whatever, for the most part, unless you're Young Thug himself, whatever the flat rate is that was initially agreed to, he probably done wore that man's money, done wore that fee out already. So now with him having to have a stand-in lawyer for basically to just be there as he either testifies or pleads the fifth and has to protect against having to go to jail for pleading the fifth, right? Milnick has to have a stand-in attorney, which is Attorney Bumpus.
The court informed Mr. Melnick that his
had
discussions with him that his leave was not proper and that he needed to be.
Again, feel free to drop any questions in the chat as we're going through this, because a lot of people don't realize it is actually illegal and unlawful. No lawyer on a criminal case can do it on contingency. So we can't be like, all right, I'm going to charge you this amount if I get you off, and I'll charge you this amount if you got to go to prison. It's illegal, immoral, unethical, and we're absolutely not allowed to do that.
Be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with court. No subject matter of the ex parte meeting was told. The entirety.
All right. Don't know if you caught that. This is where his ass is grasped. Yeah, I wore my Cornell shirt today, just so y'all know, like, I am a real lawyer and I went to a great school. I went to like a top 10 school. But his ass is grasped. And here's why. I'm gonna play what he just said again. For me, this, and I believe for whatever judge or body is going to review his conduct, what he just said is very, very important. Let me see what second is that. I want you to hear this again.
So notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland.
Keep listening.
On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with court. No subject matter of the ex parte meeting was told. The entirety of the ex parte.
No subject matter of the ex parte hearing was told. That means the judge agreed to it without knowing what they were going to even discuss. Meaning, if he doesn't know what's about to be discussed or have any concept of the content, that means he did not do a review of whether the content would be permissible. You can't evaluate something you don't know it exists. For all he knew, that meeting was about the prosecution coercing him into testify, which was in fact what happened. Him being Lil Woody. You cannot approve of an ex parte meeting without knowing what the heck they want to talk about and whether it is appropriate to discuss that topic without the defense present. Duh. Like, duh. Let me give you an example of what could be appropriate to discuss. I've given this example in prior lives, but an example of something that is appropriate to discuss in an ex parte meeting without inviting the other side would be, an example would be like when I have been like court appointed on the defense side. If I want to ask the judge and say, hey, judge, we just found new arguments that the state's expert is going to make. So we need you to approve for us to hire this expert who's going to counter what they're going to say, right? That is okay for you to have the ex parte because that's about budget, especially if you're court appointed. The court has to approve the budget for you to pay this expert. That doesn't impact the case. That impacts your ability to defend your client. But anything that's client strategy, the other side is not entitled to hear about. Okay. But when it comes to a witness that's supposed to be impartial in that they're supposed to tell the truth no matter what, doesn't matter that YSL Woody is the state's witness, because that witness is not supposed to testify with undue influence. And I'm sorry, if you lock me up during the middle of my testimony over the weekend, right? Because I'm not testifying the way that the state wants me to. Because the truth is, if he was testifying the way the state wanted him to, he wouldn't have got locked up, right? So if you lock me up because I'm not doing what the state says, then you call me into a chambers meeting without the defense, with only the state and my lawyer, which allegedly in the meeting, and we'll see, allegedly in the meeting, he's told that if he does not testify, he could be locked up indefinitely, not just for 2 years, but indefinitely. Because it was alleged that he thought, YSL Woody thought that by not testifying, he'd only be facing 2 years. He was like, you know what? Hell, I'll do the 2 years rather than be considered a rat. But then apparently the judge in this hearing tells him, in this private meeting without the defense, says, nah, it won't be 2 years. I can lock you up indefinitely. Allegedly. We won't know this until we get the transcript, which was supposed to happen today. So at the end of this, supposedly the judge released the transcript to the parties. Here we go.
Hearing held
Drop
on the
any
10th
other
of
questions you might
June
have.
of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA, Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess.
The DA's investigators. Wait a minute. Excuse me, pardon me. Why do the DA's investigators, the ones who were sitting there on video, coercing his confessions in the private room, why do they need to be in this private meeting without the defense? That's worse. That is worse than simply having the state, the witness, and you got the detectives that got the story they Sir, you sound stupid. Keep going.
From 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus.
Oh, you heard all them names? Y'all heard all those people? I have had fewer people at a birthday party. I have had fewer people at a birthday party. I've seen fewer people at a baptism. In fact, my little baby niece got baptized 2 weeks ago. She had fewer people at her baptism. And you have all these people in a hearing with respect to whether or not someone who's just been locked up over the weekend for not testifying to testify. I know if I was YSL Woody, I would be scared and frightened that all these people got me in a private room. Keep
from
going.
10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5.
Basically, what he's saying is there was not a transcript of YSL Woody talking to his lawyer, Attorney Bumpus, that they were able to speak in private.
The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time.
So he thinks, so what Judge is saying is, I never asked him what was told to him. I didn't ask him the substance of what was told to him. I just asked him who told him. The judge really thinks that he was right to hold Mr. Steele in contempt because Mr. Steele wouldn't tell him the who and not the what. Now, there are a lot of instances where it is true, it is not a violation of attorney-client privilege. For example, if it's a deposition, a common deposition question to ask the other side is to say, prior to this, did you meet with your lawyer? And someone will say yes. And then you say, I'm not asking you the content of what you said with your lawyer, but I am asking, when did you meet with your lawyer? Like, for example, they want to know, like, did you meet with them just yesterday? Have you been working with your lawyer for like weeks to prepare? That kind of thing. You are allowed to do that. I think he's comparing the two, but it ain't the same. It's not the same because at the moment you fail to invite him to the meeting, it creates the problem that grants a mistrial or for you to recuse yourself. Here we go. And the reason being, the issue isn't what you talked about. It's how it looks as it relates to justice. And then here, once you combine what you actually did talk about, oh, you cooked. You done, buddy.
Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m.
What that's saying is like the jurors just heard a snippet. The jurors heard enough to know there's an issue amongst these people, but the jurors actually don't know that he tried to jail this man in exchange for all of this. So unfortunately, they're not at this time able to even consider the level of coercion that was used.
The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant, and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele in open court.
Here we go.
Information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in court.
So what he's about to do now, he's about to outline all the reasons why Attorney Steele, y'all got my feet kicked up because I'm over here like the legal nerd that I am. Like, here we go. Here come the BS. Here come the foolishness. He's about to outline all of Attorney Steele's grounds for being upset. And then he's going to give his Rudy Poot reason for why he thinks he's okay. And we're going to discuss his Rudy Pooty reasons and why this Rudy Poot probably will not be sufficient enough for his butt to not be grassed and for Judge Glanville to get away with it and not be cooked. And again, the consequences for Glanville are he could be admonished from the, I believe he will be recused. He will either be recused by another judge, or more likely, this is how they do. This is important to know. This is how it works. Them judges will go and be like, say, man, I really don't want to embarrass you like this. And I say man, because I don't know if the other one that's looking at him is black, but if he is, this is how we talk to each other when we're not on the bench. I used to be a judge. When we're not presiding, when we're not doing this stuff, we're like, say, man, I don't really want to embarrass you like this, but based on everything I know, I'm going to have to pull you from this case. But I'm going to give you a chance and give you like 24 hours to think about it. Decide you want to pull yourself. So do not be surprised if this other judge or judges, if it's going to be a panel, I'm not sure how many are going to review this, but if they're going to review what they want to do, and then all of a sudden Judge Glanville recuses himself from the entire trial. Again, right now, he has just recused himself from the hearing as to whether or not Brian Steele should go to jail. He did recuse himself from that. And I'm sure that's because someone else told him, like, hey, you have to do it on the law or else another judge is going to pull you from it. And the next bigger issue is, does he need to be recused from the entire YSL trial? Because if he doesn't, it's a mistrial. Hell, he could, and it could still be a mistrial. But at a minimum, the one way to possibly save this case for taxpayers is if his behind does the right thing, does the non-arrogant thing, and just recuses himself. Let another judge that doesn't have all this ugliness surrounding him finish out the case so it at least looks just.
In courtroom 1C, which the court's already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the 5 to 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is
that happened.
Mr. Copeland intended to plead the Fifth Amendment.
That is what we were told.
Is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage.
Hold on. YSL Woody is not a party. Parties are defendants or the state in a criminal case. There's only the state or you're a defendant. YSL Woody is not a defendant anymore because he's immune. So he's not a party. So it's very important to distinguish between a party and a witness, because parties don't have to testify. Witnesses do, because witnesses get subpoenaed, as he was. And when witnesses are in the middle of their testimony, which he was, by in the middle, it means day one had already started. They lock him up. And then this is the day that they're supposed to pick up the testimony. So it's important to distinguish. YSL Woody was not a party. Parties are treated differently. He's a witness. It's way, way worse to do this with a witness than to do it with a party.
And that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton.
Right. So it was our understanding that he didn't want to testify. I think it was very, very clear. Well, we know he didn't want to testify. YSL Woody didn't want to testify because that's why he got locked up for the weekend. He said he was going to plead the fifth. They locked him up. So that's a correct assertion.
Claimed or said to the witness to include the court involving allegations of coercion and witness intimidation. And that he
yes, and that's the part the judge is claiming there was no coercion, there was no witness intimidation. Look at Brian Steele. That is the look of someone who knows that they are winning. Go ahead, Mr.
His counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas.
Wait, hold on. Woo! Y'all heard that? The sixth assertion is that during this witness meeting in the judge's chambers, YSL Woody admitted to committing a murder. He admitted to committing, and mind you, murder are some of the foundational accusations of this RICO indictment. Well, damn, yeah. A2I says, well, damn. So, pause. And I'm assuming, and I need to get the names right, but my assumption is that this murder is one of the foundational murders that is part of the overall charge. So, excuse me, if someone admitted to committing a foundational charge, like the murder that everyone is supposed to be going down on, you think the defendant might need to know this to be able to, because it's exonerating. It's something that lends towards someone else's motive versus his. But more than that, if you're going to give immunity to someone who has admitted to a murder, the question becomes, is this the first time they admitted? Are you aware that they admitted this prior to giving them immunity? I mean, we got questions. Right. Okay. And his attorney has stated that he never said that. I also don't think that was said because without question, that would have been something disclosed to them, as in the defendants, a lot sooner. Here's what makes me think that. And also, I don't believe that they would give anyone immunity for a murder that they themselves could. Now, yeah, they're not getting, if murder is the foundation, one of the foundational charge, the biggest, like this case isn't about a bunch of people who are carjacking or just doing like knocks and robbing people. Unaliving or some of the foundational charges. Okay. But that's the whole reason though, why you don't have ex parte meetings with the state and a witness without the other side is because you don't even want these types of rumors flying. Stephanie B, and allegedly the prosecutors threatened to charge him with perjury if he admitted to it. Gotcha. So we've got different things on there. So I do believe the reason the judge is outlining this as a allegation of Mr. Steele is because it didn't happen. The judge, he would have no reason to outline it as a contention if it actually happened. And that is in part because what the judge is trying to set up here is that Mr. Steele don't know what he's talking about. But at the same time, Your Honor, he doesn't know what he's talking about because he wasn't invited to the meeting. He may not know what he's talking about certain things, but we already know certain allegations he made were accurate, such that it was the allegation that of who was invited as far as the base people of the state, the attorneys for the state, the YSL Woody, and attorney Kayla Bumpus. Thank you. And attorney Kayla Bumpus. Those people were invited. But again, the judge's position is, no, it wasn't just them. It was also the court reporter, and it was these two detectives, and it was these other people. Sir, Your Honor, that makes it worse. It doesn't make it better. So let's keep continuing to hear. But I think the point of Your Honor giving this allegation that, that Mr. Steele has said it's his understanding that this unaliving discussion was had is specifically because he wants to use it to show how far-fetched Attorney Steele's contentions are, his claims are about this meeting, and how the meeting was not a big deal. But again, it's not for him to decide whether it was a big deal, because here's the thing. If it wasn't a big deal, why didn't you at least tell the other side? If it wasn't a big deal, why didn't you invite them? Because if it's not a big deal, you can tell them, you can invite them, and you can invite the attorney. I can understand you not wanting Young Thug to attend. And it's normal that the attorney will come in your place, especially if it's something that's going to be legal. If there's a legal grounds for the meeting, because your client's not going to understand that anyway. Here we go. Again, I have this plan on 1.5 times. So we're actually almost done. We've got about 15 more minutes.
At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage, and only considered it for the security and timeline of events that occurred on June the
Bull honky. What the judge is saying is that the judge reviewed camera footage of seeing YSL Woody's attorney. Again, I'm calling him Woody because that's what Attorney Bumpus said is the true pronunciation, but I call him Woody. Whatever. YSL Woody, his attorney, speaking with Brian Steele in the hallway. The judge reviewed this footage, and that is why the judge keeps blaming Kayla for telling. Truth of the matter, it don't matter who told. What happens is they were not under seal. The judge, if he wants to, can do anything he wants under seal. Under seal is what happens when there are certain evidence. You know, sometimes like there's certain evidence that the media or whatever will want, and the media has to file a motion to get access to it. That's because that particular evidence was filed under seal. Right now, and I'm going to talk about that tomorrow. I got a call. The grand jury is meeting right now. Well, they're asleep right now, but right now for Diddy's case, okay? That is under seal. But if you did not make this meeting under seal, she can leave that meeting and tell anybody she wants. Hell, she could have went to YouTube if she wanted to and been like, y'all. So today I was, at court, do a whole TikTok story time if she wanted to. So today my client had a da-da-da-da. As long as her client, as long as her client said it was okay, she can disclose that. But there's literally no confidentiality there. But that's how come Judge Glanville in court accused Kayla of being the one to tell. He didn't use her name, but he said she. She is the only female lawyer of all of the lawyers, like female lawyers that would be involved here. So it was very clear that Judge believed it was her who told, right? And this is the judge basically saying he came to that conclusion because he watched the video footage. But again, that's your fault. If you did not file this under, and you know why? The judge would not have made that meeting be under a protective order, be under confidentiality, because he would have had to tell the defense. He literally would have had to say, we're going to have a private meeting, blah, 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 blah. But he wanted to have it done without any acknowledgement. Somebody said, why were all those other people in the room but not the defense attorney? That's what I want to know. That's the key question. That's the question of the hour. Here we go. We keep going. This is the judge basically trying to cover his behind by creating a record that is now trying to establish the logic for why he did what he did when he tried to hold Brian Steele in contempt, as well as when he had the meeting in the first place. Mind you, the day of that contempt hearing, when he tried to hold him in contempt, that man didn't cite nary law. I did say nary. Yes, that's correct. He didn't cite nary law. He didn't cite a statute. He didn't cite anything because he was just making it up as he went.
June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not.
Covering your butt.
Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, Mr. Copeland was a sworn witness, and this was a critical stage. No, Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that.
Keep in mind, keep listening to the word critical stage. We're going to discuss it.
Point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that
keep listening, that deal with administrative matters, scheduling. Administrative, like I said, would be, hey, we need to hire an expert and we need the budget for the expert approved. Scheduling, administrative.
The judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance.
You just heard that. If the judge makes provisions to promptly notify all parties. Judge didn't tell defense nothing about it. The defense had to find out from one of the other parties present. So how immediate was that? Not only that, keep this in mind. The time the meeting was held, Brian Steele and the legal team for Young Thug were sitting there in the courtroom waiting for the hearing to start because the hearing was scheduled to start at 9. He gave you the timeline. The judge just gave us a timeline where this ex parte meeting started around 9:30 or 10. So you clearly did not promptly notify the defendants. If you could have notified them before you even had it, you could have said, we're going back here. We're about to have this meeting.
Substance of the ex parte.
And mind you, it was a meeting where he said he didn't even know what the meeting was going to be about. So how do you know, Your Honor, if the meeting is going to be administrative or about scheduling or about any of those other things when you didn't even take the time to inquire as to why the state wanted the meeting and what the context of the meeting? Did you say, is this about scheduling? Is this about this? Is this about... No, because he said he didn't even know what the meeting was about. 2:39. Let me roll this back just a second. Here we go.
And now, Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case.
Mm-hmm.
As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned, I'm going to release the entirety of the transcript to you all to use as you see fit. And
boy, F you. No. You heard what he just said. What he just said is effectively, he is trying to cover his butt. He's saying that the law says, even if it was an improper ex parte meeting, which it was, even if it was, as long as the judge promptly makes available to the other side, basically the information about this meeting, it's okay. Here's why that's not going to save your butt, judge. Is because you did your darndest to punish whoever told him. You weren't planning to tell him nothing about this meeting. You weren't even planning to tell him that it occurred. And that is very clear from the fact that you were so angry about the fact that anybody told him. You were willing to jail that person. And you were willing to jail him for not revealing that person. So why on earth would that make anybody believe that you had any intention of promptly admitting? Because if you were going to promptly talk about it, etc., you'd been like, oh, okay, well, it's not a big deal. I don't need to know, or none of this is going to prevent anything because I was about to tell you about it anyway, right? Kind of like, you know, when you catch somebody cheating or something, they're like, oh, I was going to tell you anyway, trying to play it down like, oh, it's not a big deal. He did none of that. I was going to tell you anyway. He was so mad that he found out. Second of all, this happened on June the 10th. Excuse me, baby. It's July 1st. It's July 1st. Prompt my butt. The judge, didn't even offer this transcript until a motion was made demanding the transcript. So no, sir, you don't get credit for that. Continue.
And before any other further examination of Mr. Copeland. I'll address the issue
Absolutely. I will be reading the
emergency nature of this
transcript.
particular hearing or this particular
I will be reading the transcript with voice inflections. And if I have the time, props.
Conference in front of the court is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5 507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement.
Hey, what he's saying is there was no tactical advantage. That the meeting, okay. This is important to understand. What the judge is trying to say that, hey, this meeting was us going over and explaining to him his immunity agreement, what it meant in this context and how it worked, and how if you were to do this or that, you would run afoul of the immunity agreement and problem, and these are the consequences. Like I've been saying, by him pleading the fifth, by him not testifying, he is invalidating his immunity agreement. Duh, that's law school 101. And I'm sorry if I am insulting anyone with my duh, but I'm literally using it in reference to a judge, not because of the fact that I'm so disappointed in this, in this egregious conduct of the judge. But also, if it was simply you going over his immunity agreement, first of all, that's all the more reason the defense should have been there to make sure there wasn't an element of coercion. Like the witness actually probably would have felt less coerced if the other attorney was there. Now, what I believe, and we're going to keep listening, I believe that Judge Glanville is going to imply that the judge and or the state are going to imply that he didn't feel comfortable testifying because the defendant, Young Thug, was in some way pressuring him that, hey, if you testify, something could happen to you. Now, that absolutely can happen in a case. But that's why you don't let Young Thug attend, but you should allow his attorney to attend. Or even if you maybe don't let him in the meeting, you let him listen in or in some other way in real time know what's going on. But that immunity agreement, that's discoverable. That immunity agreement should have already been provided to the defense attorney anyway. So I see no reason why they couldn't have been invited. You just trying to cover your butt, but also understand him saying at this point, the judge saying, oh, we didn't talk about anything bad. We didn't, may not be enough to cover his behind, because the issue isn't what you talked about. The issue is, what does it look like to the jurors of your county, or what would it look like to people who want to ensure justice has occurred? That's how come this was one of the charges that Judge Christina faced that got her removed from the bench. And her situation was way more minimal. Hers was about a probate case. Nobody was even facing jail time. It was about a will, but it was simply, and it was simply about giving someone an extension to file a piece of paper. But because the appearance of unfairness is so important, he ain't going to be able to get out of it, even if the court finds like, okay, what y'all talked about, you were all right discussing it. Because the issue is, you still should have invited the other side.
In consideration of these of this emergency nature, the court is taking into account a couple of cases outside for the record.
I'm going to answer
One
this one
is,
shortly.
United States versus Adams.
This question.
And that's 785 F. 2nd 917.
This is his case.
March 31st of 1986. In pertinent part.
Hold on. The judge is about to cite a case that he feels like allows him to do what he did.
Presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
All right. So that's a case where the judge is saying it supports him doing what he did. And that he's saying he's citing a case where it was the judge, the state, and a witness, and that the meeting between those without the defendant being there, it was found to be okay because the witness was saying, hey, I'm scared to testify, blah, blah, blah. And so I'm scared. So that's how come I don't want to testify. Right. So they allowed that. And he's saying that it happened at a non-critical time. Here's the problem. The difference is, and he says, and the content of the testimony had not been discussed. Here's the distinction, goof troop. The distinction is that person wasn't in the middle of testifying. Woody was. So for you to say, we didn't discuss the content of his testimony, you didn't have to. You already knew what it was going to be. Oops, here we go. Yeah, you already knew it was going to be because of the fact that he started his testimony on Friday, didn't want to testify, and you knew what his testimony was going to be because it was previously recorded with the detectives and everybody else that was actually in that private meeting. Goofy. Here we go.
And in Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. Cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about the threat. A witness may not feel free to discuss.
Pause. That case ain't gonna fly. You heard him. He just said a case where the witness may wish to speak with a judge after the witness has been threatened. The witness didn't ask to speak to the judge. The state asked to speak to the judge. That's a huge difference, because that indicates it was not the witness who was scared. It was the state.
Any threats in presence of the defendant or even counsel for the defendant. We agree with the First Circuit. The ex parte conference is appropriate in that situation. They say United States versus Arroyo.
You cannot compare a situation where the witness themselves asked to talk to the judge in private versus a case where the state asked to talk to the judge in private with a witness who's sworn in. Being sworn in means you are in the middle of testifying, and you're in the middle of testifying in a way that does not benefit the state, and you're the state's star witness.
And it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, and 1141, 1142, nope. Second Circuit case. We're
almost done, y'all.
And counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got the citation for that being.
Now, we don't know at this point, we don't know the context. Maybe that is what he's going to say, is that he got those threats. But the question becomes, okay, who called the meeting? Did the state call it, or did Woody? Maybe the state is going to say they're calling it because Woody said he was threatened. Again, we don't know yet because we haven't seen the transcript, but we will be reading the transcript on this channel. And I'm self-aware. I make mistakes all the time. This is some hair that I bought off Amazon. It's very questionable. Don't plan to ever wear it again. This is a mistake. If I'm wrong here, I absolutely will correct myself subsequently. But based on what we have so far, this ain't good.
439 U.S.
And it's not right.
Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference when frightened juror properly were transcribed and judges' comments carefully framed. This court goes on to say in Adams, two aspects of this conference are disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court with the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to.
But hold on. The judge still is not saying whether or not, when you say the terms of his immunity agreement, the question becomes, did you say you could lock him up for more than 2 years or not? Because that's huge. If he's initially saying, no, I'm not going to testify, I'll take the 2 years. But in the discussion of the immunity agreement, you're like, oh no, the immunity agreement, if it's off the table, you could face more than 2 years. You could face life, because it's my understanding that the judge had said, oh no, I'm not limited to 2 years. I could jail you indefinitely. At which point he was like, oh, heck no. Well, then I'll go ahead and testify. Excuse me, indefinite means life. That ain't that, sir. Those are not the same. Those are not equivalent. So when you watch my channel, guys, and I try to break down legal topics and I give you analogies, this is why I like to do analogies, because I feel like before I went to law school, like if I heard an analogy, I could better process and understand like why something is or wasn't fair. Thank you, Tia. Hit that like button, y'all. We got 199 in the chat at the moment. We don't have that many likes. Hit that like, hit that subscribe. Yes, Stephanie, I don't know if you heard it from me, but I absolutely was talking about in the podcast breakdown. If you haven't watched it yet, y'all, you need to watch my podcast. It uploaded, I believe it was yesterday or Saturday. It was, I was on the Poor Horseman. Once a month, I do the Poor Horseman podcast. We talk about this trial and others. But yeah, the judge is up for re-election. It's a re-election year, and he is the head judge. Think of it this way. This is how I want y'all to think about it. When you were in college, I had a rule after my first semester. I would never take a class from the department head. So if you had to take a calculus class, do not take a class from the professor who was the head of the calculus department. Or if it's English, the head of the English department. Why? That person, for whatever reason, felt the need to make everything way harder than it needs to be to like prove themselves. So with head judges, that can often be, you're either going to get one of the two. You're going to get somebody who's totally by the book, follows all the rules, or somebody who just takes the rules and throws them out like a shovel, like, who gonna check me, boo? In the words of Sheree, right? Sheree Whitfield. And that's because it's like, because they are the head, they really feel like, well, who's going to challenge me on this? The other thing that's very important is in states, and I'm not sure if Georgia is this way, but I believe they are. I know in states like Texas, our public defender system is overwhelmed. There's not enough public defenders. So what happens is you can be on what's called an appointment wheel. So a regular attorney like me, who has my own private practice, I can get appointed to a case by a judge, and they pay us to handle that case pursuant to the court fees, right? There are some attorneys where that's their bread and butter. So they don't like pissing off a judge, because you piss that judge off, he's not giving you any more court appointments. So it creates an extraordinarily unfair conflict of interest, because you got an attorney who doesn't want to piss off that judge and make all the arguments that they probably should be making, right? Because they know they don't want to piss that judge off, because that judge, if that judge doesn't appoint them anymore, they can't pay their bills, because they don't know how to do marketing and they don't know how to do those other things, because we all know law school don't teach you how to be a businessman or woman. It just teaches you what the law is, kind of. Here we go. Back on topic.
That were induced or sought by the court.
Stephanie, you got some great questions. I'm starring your questions. We're coming back.
The court's also considered Bruner versus the state. That's 302 Georgia at 6. And this relates to the right to be present and what is defined as a critical stage.
Hold on 1 second. Yes, do the time, ask the question, why would the judge even risk it? Why would he do that? And then said, maybe that's the answer to my question because he thought no one would check him. That's exactly the answer. So I starred your question. I've starred, like, I have a few questions that I'm starring. I'm going to answer them all when I get to the end of us listening, right? So that way we can attack them all. And if anyone else has a question, feel free to drop it. But yes, I believe that is largely probably why, which is that the judge simply thought, who's going to check me, boo? I'm the highest of the high. Other judges come to him when they don't know the law. He's usually the one to tell other judges, like, hey, you can't do this, or you should handle things this way. So yeah, that is also would explain why he was so livid to find out that someone dared discuss what happened in his chambers. Because think about it. As the head judge, that's where other judges go to complain or confide. So he may also want to confirm that it wasn't someone within his staff, because if so, he'd want to fire them. But baby, let me tell you something. If it was a staff member, and this comes out the way that we believe, the way that I believe, which is that Glanville will be in trouble, any such staff member who were to reveal something like this actually would be a whistleblower. They would be protected. They cannot be fired. And if they ever would, baby, that's coins. That's coins. You could win millions in a retaliation lawsuit for whistleblowing if you worked for a judge that did anything unethical. Here we go.
The Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings.
So this is another case that he's citing to support and basically claim, like, hey, this case says that what I did was just fine.
Within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the State 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of the criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the State 274 Georgia.
What I'm not clear about here is when he's citing these cases, if he's referring by saying the defendant's right to be present, does he mean the defendant himself, or if he means the defendant or his counsel? I have a feeling the cases, some cases mean both and some probably don't. So let's see.
110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way.
Okay, so he's defining a critical stage. Remember, keep listening. This is important.
In this particular case, the court is of the opinion, basing on looking at the case law, that that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the State. That's 368.
Basically, the judge is trying to say he doesn't believe it was a critical stage. I think everybody else in the legal world would disagree, right? Well, particularly defense attorneys. We would disagree that it's a critical stage, because how is it not a critical stage if your star witness is sworn in, meaning in the middle of testifying? Goofy.
68 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consistent.
There you go. That's okay. That clarifies. He's trying to say it's not a big deal that Young Thug couldn't be there because he's represented by counsel and his counsel got to come. His counsel didn't get to go to the meeting. So that's not going to count, Your Honor.
It's an essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees the criminal defendant the right to be present and see, hear all the proceedings in which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
Okay, you read that. What else you got, buddy? He's almost done, guys.
The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters.
Now watch this. All of a sudden, he's backtracking. He's trying to say, oh, we don't care now. We don't care who told. We don't care if she told or somebody else. We don't care. We don't care.
The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and our Supreme Court. So he's threatening her. He's basically saying, we can file a bar complaint and let the bar decide if they're going to punish you for this. Boy, I wish you would. They need to give her an award. You know what? At the little conference, I'm going to see if she's going to the conference in Vegas. At Vegas, they need to add her to one of the little, give her a trophy. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct.
He's claiming, this is the judge's way of saying, we're not saying one way or another if Brian Steele violated the rules of professional conduct, meaning if he should be disbarred or penalizing from using the information that he obtained, basically using the fact that he found out about this hearing. Boy, I wish you would. I wish you would try to file a complaint against him, because guess who is getting a complaint? You, Your Honor. You, sir. I wish you would. He did what he was supposed to do.
For having been explained on the record, a written order of this, along with the attachments, will be included in the record.
Yes, actually, I am coming to Vegas.
Sure. As a result of this transcript release, the court withdraws the show cause for your client and others who may be present who were present in chambers on the 10th of June of 2024. As I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So
that's the judge admitting but not admitting that he messed up by trying to have the show cause. The show cause was the hearing that was supposed to be set for Wednesday, this upcoming Wednesday, to determine whether or not Kayla, YSL's Woody's former attorney, Kayla, the one that was in that ex parte meeting, whether she was the one that told. He's saying he indefinitely has postponed that. But like, as in other words, he's not going to find out. Why? Because he knows it's irrelevant. He knows that if he tries to punish somebody for telling that, his butt's going to be in bigger trouble than he's already in. So he's saying he canceled the hearing for Brian Steele, and he can't cancel her. Basically, he's not trying to penalize anybody for whoever told or for not disclosing who told. And that indicates to me that he met with someone, whether it was someone from the ethical department of the state bar or wherever. That's probably what he did. Is got with someone from the judiciary, from the whatever. They probably worked over the weekend, drafted a memo, did the research, and came to him and was like, listen, sir, you were dead wrong. And here are some of your options.
So we will not be holding that particular hearing, okay? All right. And then
what else you got, sir?
Then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So
basically what he's saying is I was wrong. When y'all asked me to recuse myself the day that I made this ruling, June 10th, I should have, and I didn't, because I had a big ego with a big head, and I was wrong. He's not saying he was wrong, but he's acknowledging he was wrong by citing the law that they cited to him to his face, telling him, hey, you need to recuse yourself because of this rule. And he was like, no, not going to do it. I'm not going to do it. And again, why? Because he's the head honcho, and he likely had the who gonna check me boo attitude. we're basically done.
This written order is entered. I'll enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until this is, they're not supposed to come back on Monday until Monday anyway. So
These poor jurors.
I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay.
These poor jurors. Remember, these jurors are here at $25 per day. And they have been doing this for the last 5 months. Now, Georgia law encourages employers to continue to pay an employee their salary the whole time they're doing jury duty. But the way in which that would screw any small business owner, I own a title company. Baby, if my escrow officer had to be on this and I had to pay her a salary for 5 months, baby, I'm going to have to knock on the judge's door myself and say, Judge Glanville, we have a problem. So basically, because of his shenanigans and his foolishness and his unwillingness to simply recuse, boy, go. Leave these people alone. Go so they can have a clean trial going forward. But because of his unwillingness to do this, now the jury is on recess indefinitely. Now, what he's saying is that it wasn't supposed to resume until Monday anyways, due to the holiday. But we don't know how long it's going to take for whatever judge to make the determination on the recusal. Ashley wrote, how long is the process until the courts come to a resolution? It's state court. It doesn't seem to be that there is a specific, the time frame is not quite clear yet, but I do believe it's going to be handled on this state court level with urgency because of how much money this trial is costing the county per day. It says, Stephanie B asked if he canceled the hearing, can he still file a complaint against her with the bar? Anybody actually can file a complaint against an attorney with the bar, whether you are their client or not. So yes, even by canceling the hearing, he could do that, but I highly doubt he will. I think he's more so making the record so that in writing and he's probably going to upload this to his little site or whatever. He's probably making this to basically substantiate that he feels so strongly about his behavior and that he did the right thing in light of her conduct, which is, again, BS. No, the jurors did not hear any of that. No, the jurors have been out since the jurors were not there today. I don't believe at all. They've been on recess because all the stuff that happened today, this is all like legal stuff that needs to be dealt with without the jury present. It's so disheartening seeing these on the trials full of clownery. I agree. Another Fulton County trial with issues. Poor Fonnie. Wow, that's crazy. There should be a limit on how long you can hold a jury for. I'm thinking so, or pay him a regular wage. We answered this one, but I want to show it again. Do the Time said, why do we think the judge would take this huge risk by doing these things that are so patently against the rule? Again, because he's the head judge, he probably honestly did not. He seemed to be so upset in the moment that he just didn't think it through. And he'd never been in such a high profile trial before. He probably just had no idea that these advocates were going to advocate as strongly as they have. Your expertise in your craft is inspirational. Thank you. Thank you for sharing your excellence with us all. I appreciate it. I've always been told I was kind of a natural teacher when it comes to this stuff. I like educating because I just want you guys to know, for so long against myself, my family, etc., the law had been used to oppress, but I like to use it to educate because I feel like it's empowering to be able to use it to get justice for yourself and improve your own lives. Do I think this was his first time doing this? No, I don't believe by this, if you mean things like ex parte meetings, no. See, the thing is, a lot of judges, they got there to be a judge by previously being a prosecutor. Judges naturally tend to lean prosecution heavy, meaning they believe what the prosecutor says over the defense attorneys all the time. That's why I believe it's very important that the bench have both judges who have been former prosecutors and judges who have been defense attorneys. Because it really allows them to be more fair and to look at justice in a very different way. I love voting for judges who previously worked in the public defender's office. They're some of the best. So when you're doing your local elections, which is usually the midterm elections for most people, those are the ones that count most. When I'm looking through to decide who I want to pick, if I see when I'm pulling up the bios, I go to the Women's League of Voters because they have summaries. If I see that someone previously worked in a public defender's office, the reason I like them is they know of all these ways that they can make the court system more procedurally effective, to cut costs, to pay better. They have a more fair and just way of looking at things, in my opinion. Let's see, we got great question. Stephanie B was talking about, okay, the fact that the judge sat up here and said, oh, all we did was the state and we went through the immunity agreement and what it meant for, YSL Woody. So Stephanie asked, well, if that's the case, why not just ask his lawyers to explain his immunity agreement to him? Literally, that's what the lawyer is there for. Your great question, Stephanie B. Stefania, I've been saying it wrong, Stefania. You also said when the judge and the prosecutor are the ones going over it again, it feels like a threat. It feels like coercion. That's how I would feel, especially if I know that the defense wasn't even invited or wasn't allowed to be there. I wouldn't be surprised if the defense found out about it by something, for example, like if I was Kayla Bumpus, if I was YSL Woody's attorney, I'd be like, hey, how come you weren't at the meeting? And then be like, what meeting? Be like, the meeting we just had in chambers going over the immunity agreement. It would not even dawn on me that they weren't invited because I know ex parte law and how serious it is and how big of a deal it would be to dare have that meeting without inviting both sides. It's one thing if the defendant doesn't choose to show, but to not be invited, boy, you crazy. It says, yeah, we got that one. And then here we go. Yeah. Oh, feel free to drop a super chat, y'all. I'm not rich, not yet. Yes. Okay. The judge had cameras pulled from that day and saw Bumpus talking. Yes, we did go over that earlier. Said probably too much pride. The judge probably didn't think Mr. Steele had that type of backing to come to say. I agree. Yes, the transcript out, and we'll speak to a lot of it. It is out. I'm actually working on getting my hands on a copy of it. Just by the time I got through all of this, the court was closed. Did the BET Awards have too much booty? Can I sue for too much butt in my eyes? You can give it a try. I don't know that BET has a prolific legal fund for that, but let me know how that works for you. Oh, thank you for the compliment. All things glam, top tier legal professional. I love asking questions, so feel free in the chat, drop your questions. If you haven't hit subscribe, please do. My goal is by the end of the summer to get up to 25,000. I used to have a channel. If you've been following me for a while, I previously had a channel. On that channel, I did reviews with an ex of mine, but it was initially his channel, so he took his channel back, which he totally had the right to do. But I had 25,000 subscribers there, and I miss it. And so my goal is to grow this area here. So Judge Glanville said, Glanville said on the day that this all came out that he had ex parte meetings with both sides during this trial. Cool. But here's the issue. If the state don't care, don't matter. Don't matter. It only becomes an issue when a side cares. But actually, it would also depend. Thank you for the thumbs up, Terry. It also would depend on what was discussed in it. Again, his discussion with the defense, it may have been administrative. An example of administrative would be, hey, Your Honor, I already pre-scheduled a family vacation. Can we, not be before the jury during these particular days? Like, for example, this year, 4th of July is on a Thursday. I would very easily call the judge's chambers and be like, hey, I know it's on a Thursday, but I'm taking Friday. I have a family commitment. I was just seeking to find out if the judge was planning to have any hearings or anything on Friday, July 5th. That technically is ex parte, but the state's not going to care about that. Somebody said, H2OI said he could be disbarred in the Peach State. They seem to be on a roll, kicking black judges off the bitches. No, we're not going to compare those two because the other judge had initially 50 complaints that got narrowed down to 20, and some of them were really just. But I do break those down. If you look on the video with Judge Christina, I break down why that seemed to be an appropriate response based on the facts and what she was going through. However, I still am giving Judge Christina her credit that when Judge Christina was accused of ex parte, she recused herself. This judge, now he wants to get the credit for recusing himself, but the truth is, he didn't do it immediately when asked. He did it after, we do know, after the weekend, after thinking about some things, and probably after somebody came to him with a memo and said, look, if you don't do it, you about to embarrass yourself because you about to get thrown off this here case. There we go. There we go. Well, thank you guys for joining again. We've got a lot coming up this week. Please stay tuned. I'm going to be breaking down Drea's lawsuit against her ex-boyfriend, where she's basically suing him for millions based on a verbal contract, whereas he is trying to evict her from this verbal contract that's over this $3 million home that she said she wants to force him to sell her. Meanwhile, while in the home is when she conceived her baby with her baby daddy. So there's a little overlap with all of that. We're going to break that down, that lawsuit, and actually talk about why I believe Drea's got a good shot there. And also there is a new Trey Songz lawsuit. We're going to break it. Y'all, we just go ahead, hit that notification button, hit the subscribe. We got a lot of good tea, and I still got the story time coming for you. I'm definitely going to lead it up with the story time of that time that my boyfriend had called the police on me because he's a terrible person. But yeah, thank you guys for joining. Do I think Glanville would have more? I would think you would have more attacks. Watching from Barbados. Thank you. Thank you so much for joining. All right, y'all, have a great night. New subscriber, do the time. Lock it in, boo. Lock it in. See you guys later. Oh, and don't forget to hit the membership, the buttons there now that you can do that. We've got a lot of goodies coming for y'all too.